Okay. Oh. Right. And I'll sit down. Thank you.
Yeah. Yeah.
Attend the court, please. Honorable Supreme Court of the State of New Mexico.
Good morning. May be seated. Thank you. And good morning. We're on the record No.S-1-SC-39689, Shikardi and Bacon versus Wilson. Petitioner, you have 15 minutes. You may enter your appearance and begin your presentation. Good morning.
Morning.
Counsel, go ahead.
Thank you. Mr. Chief Justice, and may it please the court, my name is Harriet from Williams and Connolly for petitioner Shikardi and Bacon, and I'll be presenting argument for all three of the law firm petitioners. For two independent reasons, the court should grant the law firm's petitions for writ of prohibition and reverse the trial court's decisions denying the law firm's motions to dismiss. First, the conspiracy theory of jurisdiction on which the trial courts relied violates due process. The United States Supreme Court has held time and again that the purposeful availing inquiry must be based on the defendant's own conduct, not on the contacts of others. The law firms did not purposely avail themselves of New Mexico. The plaintiff's case for jurisdiction depends on the New Mexico contacts of third parties, namely the law firm's clients. Attributing the third-party contacts of others to the law firms on a conspiracy theory violates due process. Second, even if this court holds that the conspiracy theory of jurisdiction as a general matter does not violate due process, plaintiffs have not sustained their burden to make out a prima facie case here. The plaintiffs have identified no case anywhere in the country where a defendant, let alone a law firm defendant, was subject to jurisdiction on a conspiracy theory based on the nationwide contacts of a supposed co-conspirator. The only appellate authority to even address so expansive a theory was the Hawaii Supreme Court's decision in Kim, which involved the exact same allegations and rejected application of conspiracy jurisdiction. This court should do the same. Unless the court would like to start elsewhere, let me start with the first argument, which is that the conspiracy theory of jurisdiction as a general matter violates due process. In case after case going back for decades, the Supreme Court has held that due process requires that the purposeful availment inquiry is based on the defendant's own contacts with the forum. And let me just highlight two cases for the court. The first is Rush v. Savchuk from 1980. That's a case where the plaintiff sought to attribute contacts from one defendant to another defendant, in that case from an insurer to an insured. And the Supreme Court held that doing so was, quote, plainly unconstitutional, end quote.
What about a path that would be more the limited approach where the alleged, the parties alleged to be a part of the conspiracy, in this instance, the law firms, had knowledge of the activities and bless the activities of the co-conspirator in the subject state?
Sure. So as a general matter, we think that theory violates due process. But if your Honor's question is whether plaintiffs have made out that argument.
No, I'm
sure.
focusing on the legal
Okay.
theory, not the application at this point. So I always use the Chief Justice as my partner in these things. I'm in a conspiracy with the Chief Justice I direct the Chief Justice to take action in New Mexico. I'm not a justice here. Obviously, I'm a justice
Sure.
elsewhere. So I can direct somebody who I'm in a conspiracy with to take action, untoward action of some kind in a state, and then be off the hook because you think that would violate due process.
No, I don't think that would violate due process. I think there would be jurisdiction under a traditional minimum contacts analysis in a case where one party is directing the conduct of the other party. That is essentially a principal agent relationship if one party has the ability to direct the conduct of the other.
Well, let me make it less direct, less agency-like. We cook up the scheme, and I know that the Chief Justice is going to go use that scheme in Arizona. I've been part and parcel to developing the scheme. I know that it's going to be deployed in another state. I'm off the hook?
I think it would depend on the facts of the given case. So if in your example, the Chief Justice were a resident of Arizona and you were a resident of New Mexico and you are forming contacts with him in Arizona, I think in that circumstance, there certainly would be traditional specific jurisdiction. Now, the further removed the conspiracy theory gets from a particular forum, I think it's less likely in that situation that you as the defendant would have created minimum contacts with a particular forum simply by being a member of a conspiracy.
Do you agree or disagree that the Second Circuit in Platinum Palladium came to a different conclusion based on sort of this scenario? And they said something interesting. We followed suggestion for most purposes, the acts of one conspirator within the scope of the conspiracy attribute to others. There's no reason personal jurisdiction should be an exception. I'm curious about that quote because we are talking about theory of conspiracy, whether it's why should it be a different analysis given what the theory of conspiracy is?
Sure, because the theory of conspiracy liability is a matter of substantive liability. It is a plaintiff protective principle that attributes, acts to among co-conspirators for purposes of allowing a plaintiff to recover at the liability stage. It is inappropriate to simply port theories or principles from liability and put them into the jurisdictional stage, because jurisdiction is a different analysis that is focused on protecting defendants, the due process rights of defendants. Now, it is certainly true the Second Circuit in the In Re Palladium and Platinum case felt compelled to apply conspiracy jurisdiction because of prior precedent of that circuit. But it did actually call into question whether it was a constitutional theory of jurisdiction, as have a number of other courts. And among the courts that have actually acknowledged or adopted the theory, I think it's telling that only a minority of them actually go on to find it to be satisfied on the facts of these cases. And I think that just goes to show that courts are very discerning before actually hailing a defendant into court on this.
But you're asking as a matter of law that it's not sufficient as a concept, right? And so I do want to get into, as applied to the facts of the case, how in depth at these different district court levels has jurisdiction discovery been conducted? I suppose some of these factual questions have not been resolved.
There was no jurisdictional discovery because plaintiffs did not ask for jurisdictional discovery. They seem to have made the strategic decision not to ask for discovery, and they didn't do so in Hawaii or Oregon either. We submit it would be far too late for them to make the request for the first time now.
So I got two questions.
Yes.
First of all, purposeful availment, is it that each defendant named personally must have purposeful availment in the forum state, or is it that the conspiracy have purposeful availment? And if it's one or the other, why? Secondly, have you considered the federal RICO statute and its venue provisions in the context of due process?
Sure. So just to respond to the question about civil RICO first, I think what's unique about the civil RICO statute is that the federal civil RICO statute is that it authorizes nationwide service of process. And so courts have held that all that is required is contacts with the United States as a whole. So I just don't think that's an opposite
So
comparison.
that does not violate due process.
I haven't assessed that question because it's not
That's-
relevant here, but I know courts have held that in the federal context, that does not violate due process. Now, to answer Your Honor's first question, we think it's clear under Supreme Court case law that the defendant itself needs to create contacts with the forum, not the conspiracy as a whole. Now, a defendant might create contacts with another co-conspirator, and then that other co-conspirator might create contacts with a forum. But that's one step removed from the analysis that the Supreme Court has set out in case after case, focusing on the defendant's own contacts. Now, if the court wishes to address the theory as applied to this case, let me first just address what I think the test should look like if the court were going to adopt the conspiracy theory of jurisdiction. And I think the Santa Fe Technologies case from the Court of Appeals provides a good roadmap for what that test should look like. First, I think every court acknowledges there has to be a conspiracy and plaintiffs need to come forward with specific facts establishing a conspiracy, not just conclusory allegations of a conspiracy. Second, the defendant should have knowledge. First of all, knowledge of in-forum acts or acts directed at the forum, and we submit some participation in those acts.
So let me ask you a question about the knowledge. My recollection is in Santa Fe Technologies, the court used a know or should have known standard. So it's an objective standard. Should the standard be objective or subjective?
So we submit it should be subjective. The Santa Fe Technologies Court used in some places a clear knowledge standard. There is one stray sentence that uses a should have known standard. A should have known standard is nothing more than foreseeability, that it should have been foreseeable to the defendant that a co-conspirator would take actions in a given forum. And it's crystal clear under Supreme Court case law, Worldwide Volkswagen, for instance, and this court's case law, FDIC versus Hyatt, that foreseeability alone cannot be enough to give rise to minimum
You
context.
snuck in another element. So you said knowledge, and I think you said before you were asked a question, and they must, did you say direct the act or active?
Participate in. That language comes from Santa Fe Technologies. We submit that that is the only way to ensure that a defendant has self-created some contact with the forum. And we don't think that would make conspiracy jurisdiction irrelevant, as plaintiffs claim, because there still could be situations where a plaintiff's claim arises from the informed activities of one co-conspirator, but not the other. But as long as the other co-conspirator participated in some activity at the forum, the plaintiff could still bring in that co-conspirator under a
So you,
conspiracy.
I want to test that piece of it using my silly example of
Sure.
the justices. So we cook up a plan. I'm in New Mexico, the chief's in Arizona. And I know that he's going to go execute something in Arizona. Would I have had to do something more than that to satisfy the participation in wrong?
I think yes, but again, it would depend on the facts of any given case. So if the Chief Justice were in Arizona and you communicated with him in Arizona, that would be a contact that you would have made with the forum. Now, in that case, I think the knowledge requirement would be easily satisfied. We think even if a court adopts only a knowledge requirement and does not adopt a participation requirement, plaintiffs still have come nowhere close to showing the law firm's knowledge of activities directed at New Mexico. The complaint in this case devotes 185 paragraphs to the law firms, and there are only 2 references to New Mexico anywhere in those 185 paragraphs, both times just a generic reference to the United States as a whole, including New Mexico. That is why plaintiffs no doubt felt compelled to come forward with the exhibits that they did. And those exhibits likewise show no knowledge on the part of the law firms of fraudulent activity directed to New Mexico. The references to New Mexico and the law firms are scant for the same reasons that the Hawaii Supreme Court found those references not to establish knowledge of informed fraudulent activity. They show things like the law firm simply monitoring from afar legislative developments in New Mexico, totally legitimate activity, monitoring scientific research that happens to have occurred in New Mexico that is relevant to litigation that the law firms are handling for their clients. Totally legitimate activity, none of which would constitute.
Legitimate in some purposes, but also could be legitimate in conspiracy, right?
Well, that is plaintiffs.
Is it legitimate only because it's a legitimate activity, or does it depend on whether it's part of the conspiracy, allegedly?
Well, I think for purposes of jurisdiction, the question is whether any of that activity that the plaintiffs have pointed to and those exhibits give rise to knowledge on the part of the law firms of fraudulent activity directed at New Mexico. And there's just nothing in those exhibits from which the court could draw that conclusion. Now, in my remaining 40 seconds, let me just address the writ, why the court should grant a writ in this case. Of course, it's a matter of the court's discretion. I think there's at least 3 reasons why the court should exercise discretion here. First of all, this is an important question that deserves a ruling from this court. It is a question that has divided courts across the country. The trial court denied us interlocutory review, even though oftentimes these important questions of personal jurisdiction come to the court for interlocutory review. Second, the decisions below directly conflict with the decisions of courts and other sister states. And third, an appeal would not be an adequate remedy in this case because we would have been subject to the jurisdiction of the court.
Thank you, counsel.
Thank you.
On it.
Yes, thank you very much. Chief Justice Thompson, Your Honors, may it please the court, Rosalind Bienvenue on behalf of plaintiffs, real parties, and interest. We respectfully ask the court to deny the writ petitions here because the district courts got it right. They correctly applied long-standing New Mexico precedent that very clearly analyzed and adopted the conspiracy jurisdiction theory. No later opinion from this court or from the U.S. Supreme Court has overruled Argus or called it into question or otherwise foreclosed conspiracy jurisdiction, and it's completely consistent with due process.
We keep using the phrase conspiracy jurisdiction. Isn't just this another species of or type of specific jurisdiction?
It is, yes, I agree with
It's
that.
not something that's unique out there by itself. It's specific jurisdiction.
It is definitely part of the regular specific
So
jurisdiction
we
framework.
analyze this theory under the same factors as any other specific jurisdiction case.
Yes, definitely. Although I would say that it is unique in the sense that it is a form of allowing the attribution of one person's contacts to a defendant, whereas ordinarily that doesn't come up in every case. So I think in that way it is unique. But yes, it is just part of the regular rubric.
Is it confused or does it combine with any agency theory? Is that something?
I think it's completely consistent with agency theory. So I know the Court of Appeals in Argus says that conspiracy jurisdiction is based on agency principles. There are a lot of cases that sort of either say it's an analogy to agency or it's based on agency. And I think there's some criticism from the law firm petitioners about, well, there's no control in a conspiracy, and so therefore that analogy falls apart. And, you know, we strongly disagree with that. And I think a lot of the courts that we cited point out why they also don't agree with that. And in our view, it is true. We agree there is no control necessarily in a conspiracy relationship, but the thing or the unifying element between agency and conspiracy is the agreement that is at the foundation of the relationship. So in a principal agent relationship, there's an agreement to work together. There's an agreement on the scope of the relationship. And so we say that the acts of an agent are acts on behalf of the principal. And it's the same in a conspiracy. There's an agreement to work together to achieve a common goal. And so therefore we say that the acts of one conspirator are the acts of the conspiracy or the other conspirators themselves. So that's, you know, the unifying element between agency and conspiracy. And so we don't think that that is that is in any form of a problem. And I think you can look at some of the other courts that have addressed that, including the Kim decision from Hawaii, which we disagree with on other grounds, but we certainly agree with that part of the opinion. Maybe now would be a good time for us to address what we do think the correct test is for conspiracy jurisdictions. So, and what we don't think should be included. So, in our view, the correct test is the test laid out in Argus. In Argus, I think there is the requirement that you show that there is a conspiracy, that the non-resident defendant voluntarily participated in the conspiracy, that the defendant, to Justice Vargas's point, knew or should have known that the conspiracy would reach into the forum with acts or effects there. And I can address why we think that's an objective standard. And then that a co-conspirator's acts in the forum did in fact create minimum contacts with the forum that then you can attribute to the defendant. And so we do not think that actual knowledge is required. So I think, just find my notes. Here, to be clear, we do think we would need an actual knowledge framework, so I don't want to necessarily belabor the point, but I do think it's important if a test is announced that you get it right. So due process precedent says that a defendant's connection with the forum has to be such that he or she should reasonably anticipate being hailed into court in the forum. So that's a should reasonably anticipate being hailed into court in the forum. And that is foreseeability, but that foreseeability is described as critical to the due process analysis in Worldwide Volkswagen. So the test is not you actually have to know that you will be hailed into the forum. It's an objective test, whether circumstances are such that you should know that what you're doing is going to possibly bring you into the forum if there is a lawsuit. And so I think that's sort of the same here. It's an objective test. If all of the circumstances show that your participation in a conspiracy might subject you to a lawsuit in the forum, if that conspiracy harms someone in the forum, then I think that should be sufficient. I think there's also just sort of a practical reason why we would want an objective test rather than a subjective test. And I think that's just because in a run-of-the-mill conspiracy case, I think it would be very difficult often to show actual knowledge. To Justice Bacon's point, I think it would be rare that there would be a document saying, I know that you're going to go do this thing in Arizona, and hooray. I think that would be very uncommon. But you might have a lot of information about how any reasonable person would know that that was about to happen, and I think that should be sufficient. So,
but the petitioners would argue that, assuming that's the test, that you failed to satisfy that test.
And sure, and I can address our actual documents if that would be helpful. Sure. So I think that I think we would meet the actual knowledge test.
So you're going to satisfy a test that's not necessary.
Well, I guess, yeah, I mean, I think we have a lower bar, but we hit a higher bar, I guess would be our point. I think sort of to back up to address the documents that we have here, I think it's important, things. One, there's some discussion in the briefing about how there's such a huge volume of documents available to us. And so, therefore, I don't know, maybe the suggestion is we would have a little bit of a higher burden here. And I just want to say, the test is the test, regardless of the availability of public information.
Whether it's 1,000 documents or 100,000 documents.
Yes, correct. And I also think that the briefing in particular really looks at each of our documents and isolates them one by one and says why each one would maybe not be sufficient on its own to meet our burden. So, I think here we heard, there's only a few documents that even mention the law firm and New Mexico on the same document, but I don't think that is necessary. I mean, there's 4 parts to the test, and some of our documents support one part of that test and some of them support a different part of the test. So with that in mind, I think we absolutely have documents showing the first requirement that there is the existence of a conspiracy. And I won't necessarily go through those documents unless your honors would like me to, but I'm mindful of the time. But I mean, I'll say one example. And I should also say that the allegations in our complaint are what they are. We think they're very specific. And so the documents are supporting the allegations. They're not really separate. They go together. We make our allegations and then we make our prima facie showing. So we were very specific about the birth of the conspiracy, what the conspiracy was for, how it started. And then we, as an example of a document in support, we cited the Frank statement document. That's Exhibit C to the Shook response motion to dismiss response. And so that I think that's like what we would consider the primary, like a primary example of the conspiracy. It was a statement published in newspapers all across the country, including New Mexico, right after the conspiracy was formed. It's in the name of the first conspiracy front organization. It has all of the tobacco manufacturers signed on at the bottom, and it's just completely fraudulent what it says. It says, you know, basically it's an open question whether cigarettes are unsafe. And so to us, that's a perfect example of why the conspiracy exists. So moving on, unless we'd like to hear more evidence just generally about the conspiracy, we had a number of documents about how each law firm.
Bienvenue, do the actions of the party have to be directed at the forum, or can they be directed to the entire country? Your document made me think of,
Yes,
it was directed nationwide, correct?
yes. So I think, well, let me make sure I understand Your Honor's question. So I think there's definitely have been arguments that a nationwide conspiracy is insufficient. Is that what we're getting at? And I can.
That's part of it, but
Okay.
the other part is, in order for us to find jurisdiction in New Mexico, does the conspiracy have to specifically target New Mexico, or can it be a conspiracy broad enough to target the nation?
We absolutely think that the conspiracy can target the nation as long as it is also targeting New Mexico.
What's the support for that?
Well, I think our support would just be cases saying that every jurisdictional analysis is forum specific and case specific. And so you always are looking at the specific, you know, it doesn't matter if jurisdiction is available in California. We're just looking at whether it's available in New Mexico. And so if we meet the test and show that there was a conspiracy, there were acts and effects in New Mexico, it shouldn't matter that there were also acts and effects in other states.
Even if it's all the states?
Correct.
As opposed to, you know, maybe targeting the Southwest?
Yes, I think it's fine. And I think, you know, in our view, if the rule was that a nationwide conspiracy takes you out of conspiracy jurisdiction, I think that would really be a bad policy, because it's really just saying that sort of the worse your conspiracy is and the broader it is.
Well, how do we comport with constitutional requirements under your reasoning of how broad it should be?
I think we comport with constitutional requirements by making sure that we're meeting the test in New Mexico. So we're not saying, and we haven't said here that the conspiracy was nationwide, the end. I mean, we have pointed out what they did in New Mexico. What they did in New Mexico was not materially different than what they did in other states.
But do you think you've made a sufficient showing that the law firm defendants had actual knowledge of what happened in New Mexico?
I do think we have. And so let me pull up some of the documents I would just point out. I mean, it's in our briefing, but I think to the point I made before, I think we want to make sure we're not viewing every document in isolation, but we have documents involving each law firm showing that specific, even albeit narrow, activities of the conspiracy were in New Mexico. So I think for Shook, I'll give an example. You know, we had documents showing that they were responsible for clearance, meaning that they reviewed and approved and edited and sometimes prepared the final versions of all statements and pamphlets and documents from the Tobacco Institute. And then we had some examples of those documents. And so one in particular, there's a pamphlet that was printed for distribution in New Mexico specifically. And so in our view, that is sufficient to show clearly Shook is aware that they are creating this fraudulent pamphlet and that this pamphlet will be distributed in New Mexico. I mean, I think also sort of more broadly, we would say that in our view, because the conspiracy was designed to reach into every state and impact every American, that they knew that it would impact New Mexicans, but to the extent that feels too broad, we have these sort of very narrow specific
It
examples.
feels very stream of commerce to say you put something in the stream of commerce and ergo there is jurisdiction in all 50 states.
Yeah, yes, I think that is sort of true. I think, I mean, I don't want to conflate stream of commerce and conspiracy jurisdiction in our argument, but I do think in a sense we
But
would.
to me, saying that they knew it was going to target all states,
Yes.
that's very stream of commerce like to me. As opposed to having something more specifically targeted to a state.
Yes, I mean, yeah, and so I think to that sense, we wouldn't necessarily disagree, but I don't think we would find that to be a problem for our theory. But I can give some other examples if that would be helpful of times when, I mean, they're in our brief, so I don't necessarily want to belabor the documents, but in our view, we did present documents showing, okay, each firm knew, but certainly more broadly, that the conspiracy was coming into New Mexico, but also very specifically, they knew of certain things that were happening in New Mexico, so they can't really deny that they were surprised that the conspiracy was coming into New Mexico and having effects here. Maybe to get back to the point from earlier about whether there needs to be direct participation in conspiratorial acts in the forum in order to allow conspiracy jurisdiction to stand. And, you know, we would strongly disagree with that requirement, and we don't think it is, well, we don't think that is part of the Argus opinion, but I know your honors are not bound by Argus, but I think we disagree with how that's interpreted just generally. But in our view, it's sort of illogical because, you know, you would be requiring the defendant to have directly participated in the forum act that you're then attributing to that defendant under the theory of attribution. And so it's sort of circular. I mean, if they directly participated in a forum act, that would just be, to Justice Behill's point, just regular run-of-the-mill traditional specific personal jurisdiction. So you don't need the background of the attribution system. But the purpose of conspiracy jurisdiction is to step in when, you know, to prevent a defendant from escaping the authority of a state when they didn't necessarily specifically do something in the state, but they certainly joined a conspiracy on purpose, knowing that these acts would take place in the state. And well, I don't know, maybe this is not useful, but I have a strong disagreement about the way that we're interpreting Argus. Maybe I'll just very briefly say, I don't think in that case that it is correct that Danino, who is the defendant over whom conspiracy jurisdiction is being exercised in that case, that he did not directly participate in any act in New Mexico. And that was really the point of that portion of the opinion. It says that he actively participated in the initial contract with the plaintiff. That was before the conspiracy. And then later he approves of the conspiracy, and that sets into motion the things that happen in New Mexico. So he did not himself directly participate in any New Mexico conduct. I think in the reply brief, there's also a comment that I think it's that all of the cases that we cite that recognize conspiracy jurisdiction also involve direct participation in forum acts. And I don't think that is correct there either.
All
And-
cases of recognized conspiracy jurisdiction, counsel would argue you're, I think, are in the minority. Your position is in the minority. Can you give me a quick sense of your view of the survey, or federal or state courts in this?
Yes, we are definitely not in the minority. I think we list the cases generally that recognize conspiracy jurisdiction. It was definitely the vast majority of states that have addressed the issue. And if we look at the tests that are actually articulated in each of those states, the wording is different, but the principles are always the same. It's that you have to show that there's a conspiracy, you have to show that the defendant voluntarily participated in the conspiracy, and you have to show some form of knowledge. Sometimes I think in the Kim case, for example, in Hawaii, they do require actual knowledge. So there are cases that say that, but some say you have to show that the defendant could have reasonably anticipated that his conduct would call him to suit in the forum. That's objective knowledge.
What test in your view of those two, for example, did the trial court apply in this case? On actual knowledge?
In our view, I'm sorry, the district
The court below.
I think in this case, the court was applying Argus, and in our view, Argus is an objective knowledge test. So,
Did the judge articulate, because there's two different paths
sure.
there. Did the judge articulate where he's hanging his hat on action or should have?
No, I can't say that I think that was articulated. I guess I would call one other case maybe to the court's attention, which is the Florida case that we cited. It's Executive Tech Business System. That is a case where it is a nationwide conspiracy. There is no showing that the defendant in that case actually did anything in Florida, in the state of Florida. And the court just says jurisdiction is proper because they conspired to be part of a conspiracy nationwide that was to fix prices, not uniquely in Florida, just generally, but it impacted Florida, it changed the prices in Florida, and so therefore a conspiracy jurisdiction is permitted. So in our view, that's kind of to the point that there's no case anywhere that talks about nationwide conspiracy, or to the point that direct participation is required. We think that's sort of refutes that idea. With my one remaining minute, I think perhaps I should also talk about why we think just the writ of prohibition is an inappropriate mechanism for dealing with this. I mean, we're here, of course, but I think, you know, when the district courts ruled, they were bound by precedent that we had in the state. The precedent was very clear. There was no other opinion, definitely not in this state, that called Argus into question. And so, the district courts correctly decided that interlocutory appeal was not available because there was no substantial ground for a difference of opinion, because there is one case and it tells us exactly what to do. But so in our opinion, in that sort of scenario, an extraordinary writ proceeding does not feel like the appropriate mechanism to challenge that existing precedent. And I think it's critical to us sort of personally, and that the delay inherent in extraordinary writ proceedings can be very prejudicial, obviously. And I think this case is a good example of that, because we filed our case in May of 2022. And in the 2.5 years that have passed, 2 of our plaintiffs have passed away. I see my time is up. Thank you, Your Honors.
Thank you, Counsel.
Okay, let me start, if I may, with the concept of a nationwide conspiracy. As counsel pointed out, this is not a stream of commerce case. Now, there is a product liability claim against Philip Morris below. Philip Morris has not contested jurisdiction because it sells products in New Mexico. But even if this were a stream of commerce case as to the law firms, even in that context, the Supreme Court has made clear in the Jay McIntyre case, 6 justices agreed that simply putting a product into the stream of commerce by itself is not enough.
That was the point I was trying to draw.
Yeah, so I agree with that point, Your Honor. And just so here, simply putting an advertisement out into the national market by itself cannot possibly be enough to create jurisdiction in New Mexico. And what is more, this is an intentional tort case. The Supreme Court in intentional tort cases requires purposeful direction of the tortious activity at the forum state. Now, counsel mentioned the Florida case as the one example of a nationwide conspiracy. I just want to address that case because in that case, the Florida Supreme Court did not attribute contacts from one defendant to the other defendant. The Florida Supreme Court actually said that the defendant at issue had directed his conduct to Florida by agreeing and actually fixing prices nationwide, including in Florida, and that was conduct of the defendant himself. It was not attributing from one defendant to another defendant. Counsel gave one example of a document that she claimed showed knowledge of activity in New Mexico. This was the Tobacco Action Network pamphlet. There is no evidence that the law firms had anything to do with that pamphlet. A pamphlet was simply a generic pamphlet at some point, as the exhibits show. It was stamped with the name of a New Mexico trade association for use in New Mexico, but there's absolutely nothing showing the law firms had anything to do with the transmission of that pamphlet to New Mexico. Now, on the question of whether there was a conspiracy and whether plaintiffs have even alleged a conspiracy, counsel made the primary example of the conspiracy, Exhibit C, which is the Frank statement. I just want to point out that document was issued years before any of these law firms even represented the tobacco companies. And I think that just goes to show why it is so dangerous to, pluck these documents out that have law firm names, in many cases, decades after that document, and argue that that shows a conspiracy. Just to address the state of the law across the states, I think counsel said the vast majority of states have recognized conspiracy jurisdiction. That is incorrect. I think it is true that of the states that have recognized it, of the states that have considered it, a majority have adopted it. But plaintiffs have pointed to 13 states out of the 50 states that have adopted the theory at the level of the state Supreme Court. There are 2 states that have affirmatively rejected it, Texas and Nebraska, and another state, Vermont, that has seriously questioned the doctrine.
Of those 13, do you know how many have actual knowledge? What Hawaii?
Hawaii definitely has actual knowledge. I'm unsure about the others. I do want to point out that I think regardless of whether the court adopts actual knowledge or should have known, we don't think plaintiffs have made their burden under either of those tests. And just to address that question of whether it should be subjective or objective, it is true that the Supreme Court has said that the relevant test is whether the defendant's contacts make it such that he should foresee being hailed into a court. But the court has made very clear that the foreseeability test is tied to the defendant's own conduct, not to whether the defendant should simply foresee effects in a forum or actions by someone else in a forum. And on that point, just to answer the question as to what the lower court said, the lower court said that a defendant who has voluntarily participated in a conspiracy with knowledge, it did say knowledge, of its acts or effects in the forum can be said to have purposely availed himself of the privilege, etc. That's at page 2716 of the record proper. And to the extent the lower court was focused just on effects in the forum state, I think it's quite clear that that's an invalid theory of personal jurisdiction.
Thank you, counsel.
Thank you.
Well, thank all counsel today for their briefing and succinct and effective oral advocacy today. We very much appreciate that. In the matter S-1-SC-39689 is a petition for prohibition. On these occasions, we will recess. If we're able to announce opinion, we'll come back out and announce that. So I was asked that you stay around for a bit. If we're not able to do that, we'll contact the clerk's office and they will release you. In this matter, the court is in recess and is deemed submitted.
Can the court please